hundreds and hundreds of text messages. I just looked at my client's cell phone log this morning in the hallway before I came in here. Hundreds of text messages, including, Your Honor, more than 25 text messages yesterday.
Court does call the case. First kind of occurrence.
Alexander, on behalf of the people, Your Honor.
Morning, Your Honor. Richard Blifford on behalf of defendant Mr. Ernst is here in the courtroom with me.
Your Honor, today's date and time for an emergency bond violation hearing. At this time, the defendant is going to acknowledge the allegations that are set forth in the complaint.
Bond violation.
Bond violation, correct.
Okay. Anything from the people?
Your Honor, I'll just rely on our previous motion. I do want to say, I did mention that there could be a potential for future charges. I do need to get a little bit of further investigation done before I make a final decision on that for both defendant and defendant's mother. They were both submitted on by Ann Arbor Police.
Who was?
Defendant and defendant's mother.
All right. Okay. Anything you want to say?
There are actually quite a bit I want to say, Your Honor. Defendant.
The situation involves a married parent and a victim caught in a deeply toxic and unstable relationship that has been strained for a long time. The victim chose to seek a protection order due to ongoing tension and repeated threats that created fear and discomfort. However, the record shows there were no claims of physical violence, such as striking or hitting or any direct assault during the request for that order. Instead, the concerns focused on threatening conduct and emotional pressure that continued to build over time. The protection order was granted earlier in the winter based on the victim's own decision to seek legal distance and safety. What stands out clearly is that despite this order, both individuals continued to stay in constant contact with each other without pause. There has been a steady stream of communication through messages reaching into the hundreds, which shows a pattern that did not slow down after the order was in place. A review of the phone records confirms that the contact remained active even up to the most recent day, with more than 25 messages exchanged just yesterday alone. The two individuals also share a young child, which keeps their lives connected and adds another layer to the situation. The child recently celebrated a first birthday on April 12th, and both parents were present together at church for that occasion, showing continued interaction in person. They took part in the celebration as a family unit and even visited the fire department, where the child experienced a ride in a fire vehicle, creating
visited with the fire department and took the child on a ride in the fire truck together.
This ongoing interaction raises serious questions about how the protection order is being followed and what it means in practice.
I read through every one of these texts, and as an officer of the court, I could tell you that there is not a scintilla of evidence that indicates that the victim is scared of the defendant. The victim is asking the defendant to come and be part of her life. The defendant has Venmo'd the victim thousands of dollars since the inception of the PPO. How does he Venmo her? She calls him and says that it's money, and he Venmos her money. The victim has shown up at the defendant's house. Defendant has been at the victim's house. It's a highly dysfunctional relationship. Some of the texts, Your Honor, that the victim has given I read this morning, some of the texts, the victim is advising the defendant on how to beat this case, on what strategies he needs to be using to beat this felony case against him. And so I'm making some admissions to the court that maybe under some circumstances would be against the best interests of my client, but I've been in front of you, Your Honor. I know you're a straight guy, and I think the court would rather hear this than some nonsense. That's been the relationship that's going on here. The defendant is 31 years old, Your Honor. He's a honorably discharged member of.
The defendant has a background of military service with time spent in airborne operations along with deployments in Ukraine and near the Syrian border, which reflects a history of demanding assignment. He currently receives an 80% disability payment through the Veterans Administration due to lower back injuries linked to repeated parachute jumps during his service. At the same time, he has been working toward building a civilian future through education as he is enrolled at County Community College in a transportation technology program that has lasted 2 years. He is now approaching a major milestone as he is scheduled to receive his associate degree on May 6th, with final exams set to take place in the coming days. The court can also see that his parents are present in support, which shows he has a family system standing behind him during this moment. There has also been discussion about counseling services available through the Veterans Administration, which appear to be appropriate given the situation and may help address underlying issues. From a legal perspective, this situation has been deeply frustrating as the defendant has made choices that conflict with expectations and guidance provided to him. That frustration has been clearly communicated to him, yet it remains difficult to make him fully understand the seriousness of his actions and the consequences that follow. Even with repeated efforts, there has been a challenge in getting through to him in a way that changes his behavior and ensures he respects the boundaries that have been set.
I don't care if she shows up at your house. If she shows up at your house, you run in the house and lock the door. That's what you do. And that's how you handle it. And so there's been some monumental bad judgment here. In regards to this allegation of an ear tag being put in her car, the defendant says that took place at his house with the victim participating in this. So,
Excuse me? That he and her did it? That they did it together?
he said that she came to his house unannounced in Ann Arbor, his parents' house where he lives. They discussed putting an ear tag in the car so he would know where her and his child is, and she said that would be a good idea. And the ear tag was placed in the car. And
That's true. Then why does she have concerns when it alerts her phone?
Because it's a highly toxic relationship, Your Honor. The parents are trying to evict the parents are in the process of evicting the victim from their condominium, where the former marital home. The parents are the owner of that home. They're in the process of evicting it. It's a cluster of incredible proportions that are happening here. The amount of legal fees in this case are eye-watering, Your Honor, and I think that I come here today asking that the defendant be given another chance, and I can't promise the court that he's going to be able to control himself to not communicate with this person. I think that this brings it to a level of seriousness that we haven't seen up until now. But I think that he deserves another chance. There's no allegation of physical.
Well, and maybe counsel, and I get that they've got a child together and that there might be some conduct, although there shouldn't be.
Hundreds and hundreds.
Right. But the problem is he's the one under the court's jurisdiction. And I know you know this. And he's the one that cannot have that conduct.
And I've told him that. His parents have told him that.
But what I don't get is I don't understand this air tag. If they're having so much contact, why do I need an air tag?
Well, I mean, I could just tell you anecdotally, on my phone, I can see where my wife is at all times, and so
I can do that without an air tag.
Yeah.
All she would have to do is share her location with him, and he would know.
Your Honor, all I can tell you is I'm seeing texts as early as this morning at 9:00 at 8 o'clock this morning, texts from the victims.
The defendant stands before the court and openly acknowledges that his actions reflect extremely poor judgment, and there is no attempt to deny what has taken place. He has been advised clearly that coming into court and denying the conduct is not acceptable and honesty is the only path forward. Both counsel and defendant accept that responsibility must be faced, and there is no effort to mislead the court in any way. The request being made is for the court to consider a second chance and to strongly impress upon him the seriousness of his behavior without placing him into custody. The argument is that while the conduct is serious, it does not rise to a level that requires immediate detention. However, the court raises a critical concern that goes beyond simple communication and focuses on the act of tracking another person's location, which changes the situation into something far more serious. That element creates a clear point of concern because it suggests a deeper level of intrusion and disregard for boundaries. The defendant claims that this tracking was done with cooperation between both parties, yet the court expresses clear doubt about that explanation. The reasoning behind that doubt is based on the fact that the defendant has already failed to follow court orders, and the tone of the police report does not support the idea of mutual agreement. The report instead reflects a situation that appears one-sided and not consensual, which increases the gravity of the conduct. At the same time, it is acknowledged that the complainant initially sought a serious charge and then later made contact in a way that may seem inconsistent, which adds complexity to how the events are viewed. This combination of actions from both sides creates a layered situation that the court must carefully weigh while still holding firm on the importance of following legal boundaries and respecting the conditions that have been set.
But also the whole tenor of the police report, which I'm sure you got a copy of,
I did.
doesn't indicate that this is anything cooperative on her part.
I know, but Your Honor, this is also somebody who went and sought a stalking charge and then went and contacted the person saying, this is the police understanding here. I never meant to see you charged like this. So you have a very frenetic victim here who is, on what day of the week, it's a toxic relationship. These people do not do a good job communicating with each other. So if for chance, she asks for a Venmo and it doesn't go through, guess what? She's off to the police department. That's the nature of this relationship. And that's something that needs to be resolved via the divorce. But this is an insane relationship here. And from what I gather, and I'm not a testifier, from what I gather, it doesn't rise to the level of striking each other or hitting each other in the face or that type of thing, But as far as, daggers out and just sort of crazy conduct, these people are involved in a spiral of crazy conduct with each other. They're both part of this crazy conduct. Both of them. But you're right, Your Honor, the defendant is the one who's here in court. The victim is not in court. She's not on the court doesn't have jurisdiction over her conduct as to whether she shows up at his house. And so it's just been bad judgment. It's terrible judgment. And, that's it's funny because, I thought long and hard about this weekend. What am I going to say to you? I really, belabored in my mind, what am I going to say to you? And this is what I'm going to say to you. And I think he deserves another chance. I do believe he can fly straight. And that's our prayer to the court, Your Honor.
So
I did also want to note in the court that our victim advocate did speak with the victim today, and I also spoke to the hallway. That's where I was before this, and I didn't have any mention of any of that, including the cooperative AirTag on her part. I told her she can leave before this because she was not testifying. She wanted to leave. She didn't want to be present today in the courtroom, but she did not mention any of that. And I have not seen any of these texts either.
But she did not indicate that this was somehow cooperative or somehow
No, Your Honor.
that the police report itself was some type of misunderstanding.
No.
Did she indicate to you that the entirety of the case was a misunderstanding?
No, she informed me that, and I was just throw it, she wanted him to get out. And she was concerned about his parents and what was coming with that. So she just had concerns, with what was going on.
There's a highly conflictual relationship between parents and the victim as well. It's like, it's off the charts, Your Honor. Mainly revolving an eviction.
How old's the child?
The child just turned 1 year old on April 12th. That's when.
This is the part that's phenomenal to me. I've got the parents at each other in some way. Well, I think somebody may have arrived.
At this point, the situation has expanded into multiple legal fronts, with a divorce underway alongside a stalking case, and even the possibility of an eviction, which adds pressure and confusion to an already tense dispute. The properties involved appear to fall outside this court's jurisdiction, which further complicates the overall picture and raises questions about why each issue continues to escalate instead of being contained. The court makes it clear that while it understands the argument being presented, there is still a strong level of concern that cannot be ignored. After reviewing the motion over the weekend and carefully examining the police report, the court expected a clearer explanation that would align with the facts on record. Instead, there remains a gap between what is being claimed and what the evidence appears to show, which creates doubt that is difficult to overcome. The court emphasizes that it is not seeking to escalate the matter unnecessarily, yet it cannot ignore inconsistencies that stand out. A key issue centers on the presence of a tracking tag, and the explanation provided does not match the circumstances described in the report. In a world where both parties are using modern devices, the idea that the tag served a harmless or neutral purpose does not align with the surrounding details. The court even considers placing the complainant under oath to clarify the situation directly if needed, which shows how seriously this point is being taken. It is acknowledged that attorneys must present the information given by their clients and advocate based on that account, yet the court signals that the reasoning offered for the tag simply does not fit with the documented event. This disconnect leaves the court struggling to accept the explanation and reinforces the need for a clearer and more credible account before any conclusion can be reached.
All attorneys things, and I get that then the attorney has to come up and you have to say what the client's telling you. I get all of that. But I'm telling you, that notion of why that tag's there doesn't fit with anything I see in the police report. Doesn't fit, and maybe in certain relationships, it doesn't fit with any common sense I know of, but that can happen. But it doesn't make any sense. And now that she's here and Ms. Zenta, I'm presuming, available to testify before the court, if necessary.
Yes, but if that were the case, I would ask to briefly pass it so she could speak with my victim advocate. And
Understood. I don't know. Well, hold on a second, counsel. I don't know if your client wants to change his position on what he's had laid to this court about that air tag.
If we could pass the matter, and I would say to the court that we're not necessarily sharing testimony day. But
I know, and I'm not, and understand that
but
let me just say this. I look stupid, but I'm not. And the problem is that I realize your client has said that to you, you've relayed it to the court. I don't doubt in regard to any contact that you told him what you said you told me. I don't doubt any of that. I'm just having a real tough time believing your client's premise for why that's. And I'm sure because you have been before me. And one of the things, the worst thing is, if you lie to me, we're going to have a whole other set of problems.
Understood, Your Honor.
So what I will do, knowing that she's here and that I may take testimony, I'll pass the matter so that the victim's advocate can talk with her, you can talk with your client, and then somebody wants to give me a story that makes some sense. Fine. All right. He is to remain in the building. It's not to leave.
Of course, Your Honor.
All right. Is that all I've got for 11? And why is he here yelling at me then? He's over there screaming at me. Judge, get moving. I'm sorry. That's what I heard. I don't know. Court's gonna stand in recess.
All rise. All right. 14A, District County, Washington State of Michigan.
Court recalls case people versus Connor.
And then people, Your Honor.
This time the defendant is offering a no contest plea to the allegation, that being that he's able to articulate the facts, and we would stipulate to the police report as a basis.
Anything else from the people? This time, this is currently set for the ETC, I think this Thursday. So we'll continue the matter to the probable cause conference this Thursday at, is it 23rd? April 23rd, 2026, 9 a.m. At this time, given the admission to no contest, but admission to the violation, the defendant's bond at this time is revoked. Defendant is remanded.
Thank you, Your Honor. Thank you again for your time.
Thank you, Your Honor.